Maneva na say ma PENDREAM TV. PENDREAM TV there osia dem yopo.
Well, so I mean, this one is not anybody's personal idiosyncratic view about what should be contained in the petition. It's the Constitution that provides guidance. And so the Constitution in Article 146(1) provides what should go into a petition to remove the Justice of the Superior Court of Judicature or the Chief Justice. And the Chief Justice is the Justice of the Superior Court of Judicature. So from the High Court, Court of Appeal, the Supreme Court. Now it must be on stated misbehavior or incompetence or inability to perform a function because of infirmity of body or mind. And so it's clear. Now even with the inability to perform because of infirmity of body or mind, if it is a mind, you have to establish a committee of medical team to know whether his mind is still working or not working. And so that's a different matter. But stated misbehavior. I mean, so I'll give you an example. I mean, justices of the Superior Court of Judicature and all justices are supposed to be neutral, non-partisan. So if in your village you chance to see a justice of a Superior Court of Judicature mounting a political platform to campaign for a political party, that's stated misbehavior. Stated, you don't need any other thing. You can remove that justice from the bench on that basis because it's stated misbehavior. Incompetence. He writes a ruling, and when you read the ruling, it doesn't follow any legal or judicial precedent. And there are no legal principles or precepts. I mean, so you question his competence as a judge, incompetence as a judge. Now, so when it comes to electoral commission, why are we talking about incompetence? So the commissioner, electoral commissioner, enjoys the conditions of service of a court of appeal. So her removal process must be equal or similar to the removal process of a justice of the court of appeal. So when we talk of incompetence of the electoral commission, it's not incompetence in terms of judgment, but incompetence in the performance of her functions. Okay, or stated misbehavior. So this is what I mean. If you have reasons to believe that the EC commissioner or her deputies have done something that clearly is a stated misbehavior, you put it in a petition and send it to the president. Or you think that she has been so incompetent that incompetence is not to be tolerated or accepted of a body like the electoral commission. You put it in a petition and send it to the president. So that's it. So the Constitution gives us guidance. Okay. Now and this is the first time you have about 10 petitions being sent for the removal of the EC commissioner. It's the first time. I mean, so it's huge. So it means that there's a general perception of people that the electoral commissioner and her deputies engage in some form of misbehavior, stated misbehavior or incompetence, and so they wanted them out. And it's a right vested in any Ghanaian to petition for the removal of the EC commissioner and her deputies or the special prosecutor. It's a right. Now, so when the people sent and I agree, I'm shocked at the decision because when you look at that the decision of Justice Bafo-Bone against earlier decisions, you find it difficult to rationalize his decision. And let's give you one example. The Constitution again gives the EC the power to create constituencies. But in the creation of the constituencies, there are certain procedures to be followed. The constituency must be created before the next election. Because if the constituency is created now, the people they cannot be represented. Okay? So when you create a constituency after the holding of elections, for the full 4 years, the people cannot be in parliament because you cannot I mean, we did that to prevent gerrymandering. I mean, and bastardization of the electoral system. And so, if not, the government could create more constituencies in the MPP areas to further decimate MPP if we allow that. So the whole rationale is to lock it in and make it impossible to determine the outcome of an election when a sitting parliament is there, and also not to change the composition of that parliament. So in 2020, EC created constituencies. Created who? Hohoi. Okay, and in the creation of Hohoi, it left 4 communities. 4 communities. Sal, Apafo, Lolobi, and Lipe. Left them. Now, I was in Parliament. The EC Electoral Commissioner came to Parliament. The late MP of Hohoi drew the attention of the EC Commissioner in Parliament that the description of the Hohoi constituency seemed to exclude 4 communities. And if that was not rectified, the 4 communities would not be represented in Parliament. So it was not something that was not brought to her attention. It was brought to her attention. Now, somehow, for 4 good years, the people of Santrofi and Apafo, Lolobi and Dikwe were not represented in Parliament. Look at what the Chief Justice says. Oh, you don't want me to read the Chief Justice's report? It says, while the allegations raise serious constitutional and administrative questions, they do not on their face meet the threshold required for a prima facie determination of stated misbehavior or incompetence warranting that a committee be set up to inquire into the petition. So Chief Justice says that, well, such constitutional breaches or administrative breaches are so serious. Okay? But that on the face of it. So that's where I disagree. Do you need intentionality? Do you need to prove intentions when you are breaching the Constitution? You need to prove the fact that a constitutional provision that has been breached. That's all. And whatever motivated move that person to breach the Constitution, it's a secondary matter. The Constitution has been breached. And you can't use intention to obviate the requirement of the law to question the competence of that person, because it's a constitution. The constitution says you must do it this way. If you don't do it that way, you are incompetent. And it's not that the constitution is some locked book somewhere that you always have to go. Everybody has a copy. Everybody has a copy. All this must be. So then the Chief Justice says, it's not that weighty. For now, we now know that there are some constitutional provisions, the breach of which are not weighty to require inquiry. So this is a problem. This is a problem, and it has thrown almost all constitutional lawyers, and lawyers in particular, into confusion. Because you look at Charlotte Otey, it was not a constitutional breach. It's an alleged procurement law breach, statutory breach. That was weighty enough to require the setting up of an investigative body for her removal. It was not constitutional. Look at even the recent Supreme Court judge. It was not a constitutional breach. It was an administrative breach. That she used public resources to buy a ticket for the husband and the daughter. It's just administrative breach. That was weighty enough to cause her removal. The Supreme Court is not saying, Justice Bafwell is not saying that for some trophy Akwafu, Lolobi, Likwe, even though they were not represented in Parliament, the breach by the Electoral Commission was not serious. Was serious but not weighty. And so he doesn't find a proper fashion. So what do I say? I say that probably we're dealing with a Chief Justice who is an institutionalist. So everybody comes to the bench with his own personal idiosyncrasies. So Sofia Akufo did not see any qualms. He had no qualms dealing with that institution and removing Charlotte said, no. Well, so if the institution is even going to suffer credibility problems, the person has breached procurement. So I'm not going to save the institution by undervaluing the breaches of the Procurement Act. That's a view. Or in the recent Council of State, so well, we won't save the Chief Justice because there were administrative breaches. But it appears to me that Bafoboni, and from going forward, we will see how his judgments will read. It appears to me that he's an institutionalist. He's interested in his understanding and appreciation of our democracy is founded on strong institutions. So he will not do any unless the evidence is so clear and indisputable. He will not do anything to shake the foundation of institutions of democracy in our country. It appears to me that is what I'm seeing. Because if not, it appears that Charlotte Osei was subjected to a weaker standard. Weaker. And so you look at consistency. Or even now we can argue that we can now argue that probably Tokuno was subjected to a weaker standard. Okay, so that is the inconsistency in judicial pronouncements and pronouncements of this nature, and has thrown the whole Article 146 again into debate. So he says threshold. So what is the threshold? Who defines the threshold? Where can we find evidence of that threshold to inform ourselves and guide our future petitions? So these are the matters that his ruling is evoking. It's not that NDC called for the removal. I mean, I don't remember. I was part of the Constitution. Manifesto committee. There's nowhere in our manifesto, especially in the governance architecture, where NDC said, "Look, when we come into office, we will remove the Electoral Commission, or we will remove the the OSP." There's nowhere. Okay, but we said we are going to hold governments, institutions accountable, appointees accountable, people occupying some institutions accountable. So probably because we said that, people relied on that to send in petitions for us to hold those institutions or persons occupying those institutions accountable. But NDC as a political party did not promise the people that when we can, we will remove those people. No, we didn't do that.
Can the petitioners, ask for a review? I don't know. Yesterday there was a heated debate in Parliament. Not even the debate hasn't started yet about the decision or the move, by the ministry responsible for chieftaincy and then religious affairs to initiate the registration of churches and other religious bodies in the country. So that happened in Parliament yesterday. And this morning we were having an argument and debate on that as whether we really need to go beyond the registration. Because initially, if you look at the PNDC Law 221/1989, it gives you that clear indication, except that people opposed that move because they felt that the state was interfering in religious affairs. But we're going back to the drawing table, this time to register those churches. And I think that, that should be good. My question to you, Mr. Alhaji, I want to start with you on this one. If this should happen, should we look beyond that, the registration of the churches? Would that be seen as a hand in the affairs of religion by the state?
I think that we are confusing two things. We are confusing the freedom to worship your God, freedom of religion, with the regulatory function of the state. Okay? So you are free to register, to practice your religion, provided the tenets of your religion or your faith is not inconsistent with the laws of the country. You're free. Okay? But how do you do it? Because we have failed, refused, or neglected to register and regulate how they do it. See how...
It's free for all.
You wake up in the morning and one form or another of a church or a mosque is sitting just opposite your house. And you can't sleep. You can't sleep. And then you read about people who cast demons and how individuals are chained to trees, to buildings and whatnot to cast demons. And in some cases they are even flogged. They are even flogged. You see, so there are two different things. I'm just going to say that because we are in the month of the fasting, I'm not going to talk too much on the religion, but I'm just going to say that you are free to worship your God in the way you think you have to worship your God, provided the way you are worshiping your God is consistent with the laws of the country. But the state has a responsibility to regulate religion, okay? Regulate the way things are done in this country. And that is why the state is going to register religious bodies and ensure that they operate within the ambit of the law in this country. And these are two things. The state will come and tell you, don't use the new version, what is it? King James version of the Bible in your church. The state will not tell you that. Or the state will not tell you that don't come and don't be a Sunni or a Tijani. The state will not tell you that. But the state will say, if you want to practice your faith, we must know that faith and how you intend to practice it. And that's all. We're just trying to force us to accept a narrative that doesn't make sense. If you look at it from the policy point of view, if you look at it from the propaganda point of view, it doesn't simply make sense. Now, do you know that the 2001, 2002, 2002, 2003, 2003, 2004 financial statements of the Cocoa Board have not been made public? Have not been published.
From 2000?
From what? 2001, 2002. That's not been made public. And meanwhile, they are not talking about
2021 and 2022.
2021, 2022, 2022, 2023, 2023, 2024. Meanwhile, they are not talking about that too. Everybody is not talking about that. That the law mandates a chief executive and management to publish
Annually.
They're not talking about that breach. And why haven't they published? They have not published because of the debt to which they sank this thing. Little wonder that Cocoa Board is indebted to farmers, or Cocoa Board debt stands at 32 billion. And I see this. They also fail to see that when you make a promise, it's a statement of intent. Taking all the conditions available to you at the time that you are making that promise. That if situations continue this way, this is how I'm going to treat it. It's a statement of intent. And they don't know that too at this party. And then you have price mismatches. I mean, all of them who are speaking at the press conferences, haven't they made promises to their wives or their children who they have not been able to fulfill? Because they made them at a point, taking certain conditions into consideration in making that promise. But they have changed. Conditions have changed, so we can't do it. You know, Go, like you have said, Africans. They are crying now. We have where the farmers can go and say we want our money. In Africans, they can't even get the buyers. They can't get them. And they are now packing. They are loading their cocoa in their houses. Now, but why have they cut salaries of management and other staff? Because to whom much is given, much is expected. Your predecessors ran down the establishment. Farmers have labored to supply cocoa. They have not been paid. Meanwhile, you can't continue to enjoy your salary when the farmer, who is the reason why you are in management, is suffering. So they are meeting. It's a demonstration of empathy, concern. That look, we also have something to do. We must do something to meet the reasonable and legitimate expectations of the farmers. That the farmers cannot be suffering when we are enjoying our salaries. So say, well, we management, we have voted to take a 20% cut, and other staff have voted to take a 10% cut. And last week I was reading that this cut will yield about 40 million, and they are using that to pay cocoa farmers. So if you want, you can say it's a patriotic act, and if you want, you can say it's a prudent decision.
Yes.
Is it not maybe perhaps as a result of fat salaries rather?
Whatever. You can't reduce your salary if the management of TV Africa reduces your salary to your disadvantage. Won't you cry here? Won't you cry here? So that's why it's a voluntary thing. That's why they are voluntarily. Because you can't cut. It's like stability. You can't reduce the salary of a worker to his disadvantage. So, but the worker admits that the situation requires that they do something extraordinary. So this is a selfless act of empathy towards the farmers by the management of Cocoa Board. And that's what I invite the MPP and the minority parties to look at. They ran us into this, but we're trying to get up.
Let me see if I can quickly read some messages on our social media platforms. Let me do this from Facebook. It says from Edward Dubaza, I totally disagree with the CJ that there is no prima facie case against Jane Mensah and her cohorts at the Electoral Commission. We all know how Jane Mensah and co manipulated the electoral machines, in favor of the NPP. All right, so let me just go straight to WhatsApp. Good morning, my senior comrade Pratt. Just curious, are the shrines also going to be registered? I agree with minimum qualification. Can that also go for our brothers and sisters in African traditional religion? All right, so please add your names to the messages. Good morning, my senior comrade. Okay, it's the same question. From Kwablavi of Pokwasi, Benghazi, says Dr. Bawumia leading NPP party into the incoming general election is a disaster for NPP. As it stands now, NPP party members are not sure of anything positive from Dr. Bawumia. Thank you for the message. Good morning, Mr. Tokuno. If a whole constituency like SAL can be denied representation by the EC for 4 years, and the CG says he cannot raise a prima facie on this matter, then I cry for Ghana democracy and human rights. Stephen from Kwabenya. Hello, Dave. The ease with which the CG, during his vetting before Parliament, stated why he gave Atai a long sentence shows how he can be inconsistent and unpredictable. Uncle Sam from Spintex. Dear host, while the decision of the CJ is fait accompli, I am looking forward for fresh petitions for the removal of Jane Mensah and her deputies. In 2020 general elections, Jane Mensah announced 6 different results. So which one made her declare Akufo-Addo the president? Is this not incompetence which could have thrown the country into chaos and upheaval? The escape from removal of Jane Mensah and her deputies has a serious ramifications for the country. Good morning, Charles Ejepon, Secretary Humjibre in the West End of. Thank you, Charles. I am totally disappointed in President Mahama and Bafo Boni CJ. CJ Bafoboni for bending backwards to no, please. Good morning to you, Mr. David, and to your able panelists. Most people can now feel that Ghana is now working, but I feel so sad with the manner NPP folks are behaving so negatively on various platforms. They don't take time to learn clearly about certain issues. All right, please keep it short so I can read all. Sami Boachi Asamankesi. Regarding the removal of the former Chief Justice, I believe it has brought embarrassment and disgrace not only to the president but also to Ghana as a whole due to pressure from his own party. It appears likely that he may take similar actions in the future. All right.
PENDREAM TV now, so far so good. Say open online portal Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.